Good morning and good evening. Good morning in UK, United Kingdom, in Brighton, and good evening in Auckland, in New Zealand. So my name is Roland, and together with my colleagues, Ms. Urbanova and Ms. Lal, we will be hosting a match, a day 3 match for the Group G. It will be the third match for Brighton, but it will be the second match because there will be a day 1 match afterwards for Auckland University of Technology. So the two teams are here and we are ready to have the match. So I give the floor to Miss Lal.
Thank you so much. The topic that the teams will be debating on today is multinational corporations must terminate supplier contracts linked to severe human rights violations under international due diligence principles. Before the members start debating, let's first get to know each team member better. Starting off with the University of Brighton, could we hear from Mr. Peter Batica, please?
Hello, everyone. My name is Peter Badica. I'm glad to be here to participate in this debate. I'm from the University of Brighton, studying law, and I wish everyone good luck.
Thank you so much. Now from the Auckland University of Technology, Mr. Jazz Chetwell, please.
Hello, hello to the competitors in Brighton. I'm Jazz, currently studying a Bachelor of Laws. I'm currently in my second year, and I'm excited to be here.
Cool, thank you so much. From the University of Brighton, Mr. Cameron Hall, please.
Hi, I'm Cameron Hall. I too am also studying law at the University of Brighton and looking very much to this debate here.
Thank you so much. From Auckland University of Technology, Mr. Treyman Thompson, please.
Good evening from New Zealand. Good morning to Brighton. My name is Tremaine Thompson. I'm a second year Bachelor of Law student here at the Auckland University of Technology.
Thank you. And last but not least, Mr. Thomas Mears, please.
Hi, thank you for having us. I'm excited for this debate, and thank you for our learned colleagues for staying up for us. We're also waking up a bit early, so I think it's late on or early on both sides, but thank you for that.
Thank you so much. Now we will allocate the positions. So if Professor Laurent could please share the screen.
Yes. So can you see on your screen the wheel?
Yes.
Yes? Okay. So as you can see, there are two possibilities for each institutions to be in favor and to be against. The team will be in favor will be starting the match with the first introduction. So for this match, Auckland University of Technology will be in favor of the motion. It means, and we'll be starting with the first introduction, and it means that University of Brighton will be against the motion. So now you will have 5 minutes to review your notes, and then we'll hear the introduction from the team in New Zealand.
Okay, that marks the end of the preparation stage. Just a friendly reminder, Ms. Urbanova will be our timekeeper, so please ensure that you can see her. And the two cards, the yellow card being 30 seconds left, and red card implying that time is up. You may comfortably finish your sentence, but it is not recommended to start another. With that, we will first hear the opening statements for the team in favor. Auckland University of Technology, you have 4 minutes whenever you're ready.
Thank you. Honourable judges, you cannot outsource production and then outsource responsibility. Global supply chains do not just move goods, they move responsibility. This case turns on a single question. When a corporation is linked to severe human rights abuse, what must it do? We say where harm cannot be prevented, the relationship must end. Our case is structured in 3 parts. First, international law requires companies to end complicity in harm. Second, where harm persists, termination becomes necessary. And third, without termination, exploitation continues. Under the United Nations guiding principles, companies must identify, prevent, and mitigate harm. And under Principle 19, they must act to seize or prevent their contribution. Where linked through a supplier, they must use leverage, and where that fails, consider terminating the relationship. This is not optional engagement. It is active responsibility. Where you have influence, you have responsibility. The International Court of Justice in the Bosnia genocide case confirms that actors must act where they have the capacity to influence harm. Corporations today exercise that influence. And domestic courts confirm this trajectory. In Vedanta and Lungowe, and Okapabi and Shell, the UK Supreme Court recognized that corporations may owe duties for harm across global operations. Corporate structure may divide operations, but it does not divide responsibility. So companies cannot remain linked to harm without responsibility. So once responsibility is established, what must be done when harm continues? Well, the law is clear. Engage first, but not indefinitely. The OECD guidance requires leverage, and where that fails, responsible disengagement. Leverage without consequence is not leverage. It is tolerance. Where severe violations persist, continuing the contract sustains harm. And under the EU Due Diligence Directive, termination is recognized as a necessary measure. At some point, continuing the relationship stops being engagement and it becomes endorsement. Where mitigation fails, continuation becomes participation. If companies remain, abuse remains profitable. Violations continue. This undermines obligations under the ICCPR, the ICE SCR, and ILO forced labor conventions. Without termination, exploitation continues. So this case really is not about whether responsibility exists. It is about whether it has consequences. Because when harm cannot be stopped, continuing the relationship is not neutrality. It is participation. Thank you.
Thank you. Now for the opening statements for the team against the motion, University of Brighton, 4 minutes whenever you're ready.
Honorable Judge, about whether human rights matter or not. We all agree they do. This debate is about the real world. Our team contends that terminating supplier contracts does more harm than good because it removes livelihoods, reduces overrate, and fails to address the root causes of abuse. Our team believes that corporations should remain engaged and use their leverage to improve conditions rather than abandoning workers through termination. This debate must be judged on real-world outcomes for workers, not on moral symbolism or corporate image. We have 3 arguments I have 3 arguments in my case structure. 1, termination harms workers directly. 2, engagement is more effective than exit. And 3, even well-intentioned reforms may backfire. I will use the Iraq method to build my case. Starting now with my first argument, terminating supplier contracts directly harms workers. And this is because suppliers depend on corporate contracts to sustain employment. When contracts are terminated, factories may shut down, workers may lose jobs, workers then are pushed into informal or unregulated sectors. These workers often have no safety net, meaning termination increases poverty and vulnerability rather than reducing exploitation. An example of this is the UN guidance explicitly warns that companies must consider whether ending relationship causes adverse human rights consequences. Therefore, termination punishes workers rather than protecting them. On my second argument now, engagement is more effective than termination in improving human rights. The reason for this is that corporations have leverage over suppliers when they remain in the relationship. When companies stay engaged, they can enforce labor standards, conduct audits, and apply economic pressure for reform. Were they to leave, that leverage would disappear, and suppliers may continue abusive practices without oversight. An example of this would be the international guidance that encourages engagement over disengagement because it allows companies to influence behavior. Therefore, if companies stay, it enables long-term improvement, while leaving removes the ability to create change. And on my third argument is that even well-intentioned reforms can harm workers. This is because compliance increases the cost for suppliers. To cope with increased cost, suppliers may fire workers, replace workers with machinery, or increase pressure on remaining workers. This leads to job losses and increased inequality, meaning that attempts to improve conditions can unintentionally worsen them. And evidence of this would be the Rana Plaza disaster that shows that compliance pressures led to job losses and worker exclusion. If reform already creates harm, then terminating contracts entirely will only worsen outcomes for workers. The affirmative team says that termination creates pressure for change. This ignores that pressure only works when companies remain engaged. Once they leave, suppliers lose accountability, continue harmful practices. At its core, this motion provides symbolic action of a real impact. It allows corporations to appear ethical by walking away instead of doing the harder work of improving conditions. Real responsibility means staying, engaging, and using power to create change. For these reasons, we proudly oppose this motion.
Thank you so much. Now for the first round of rebuttal, starting with the team in favor, Auckland University of Technology, 2 minutes.
Sorry. The opposition is contending that staying in these forms of agreement when human rights violations are actively occurring is beneficial to protect the livelihoods of the victims. This ignores a critical, legal, ethical, and moral doctrine. When a company continues operating with a supplier despite knowledge of unremediated abuses, its role evolves from direct linkage to active contribution. At that point, the company is no longer just a bystander, it is helping sustain the harm that it is claiming to mitigate. Again, remediation, yes, but where is that fine line? The argument my opposing team raises about protecting workers also assumes that continued engagement is effective. But when and where mitigation efforts fail, staying does not protect livelihoods. It prolongs the exploitation of victims, and it's hidden under the guise of attempting to correct the issues. A job under conditions of forced labor or severe abuse is not protected livelihood. It's a basic human rights violation that's being sustained. Staying in these supplier contracts attacks basic human dignity. At some point, the obligation becomes a must. If harm cannot be stopped quickly, continued presence becomes complicity. Therefore, then, termination is the only legal, moral, and ethical decision to be made. Thank you.
Thank you. Now for the first round of rebuttal for the team against the motion, University of Brighton. You will have 2 minutes.
Thank you. Our learned colleagues claim companies can't outsource responsibility, and we agree with that entirely. But they've confused the existence of responsibility with the form that it takes. Our learned colleagues claim that when harm persists, termination is the only responsible action, but that's not what international law says. UNGP Principle 19, which they've cited, requires companies to use leverage to prevent and mitigate harm. But read fully, for supply chain relationships, the standard is to use leverage, not exit. So their own authority contradicts that conclusion. On the ICJ Bosnia genocide case, that concerned a state's obligation under the Genocide Convention. It doesn't apply to private corporations in purchasing relationships. State obligations onto private supply chains is a misapplication. On Shell and Vedanta, both concern parent companies with direct operational control over subsidiarities. That's categorically different from MNC buying goods from an independent supplier. Proximity and control are the operative legal concepts, and they are absent in the standard supply chain relationship. Responsibility exists. We've never said otherwise. But responsibility under international law means to act proportionately, identify, engage, escalate, remediate. What it does not do is collapse that entire framework into one binary, terminate or be complicit. That is the proposition's invention, not the law's instruction. On the next issue, the CSDD imposes civil liability, fines of up to 5%, global turnover, and mandatory action plans. Termination appears once as a last resort after all the prior steps have taken. The opposition said leverage without consequences is not leverage, and we agree, which is why the CSDD creates consequences, which is civil liability, administrative fines, etc. The case is therefore not about whether responsibility exists, it's about whether termination is required consequence. Thank you.
Thank you. Now for the second round of rebuttals from the team in favor, Auckland University of Technology, you have 2 minutes.
The opposition contend that staying in these contracts where human violations are occurring is actually encouraged by the guiding principles of leverage or remediation. This misconstrues what the principles actually require. An example of this is from an open letter from the Civil Society of Organizations, including the Anti-Slavery International Organization and around 15 other signatories, where it's outlined in their very first recommendation that in accordance with the UNGP guidelines and the OECD guidelines, ensuring termination of relationships is key and should be done responsibly. Again, yes, engagement is encouraged, but only to the extent of that is what is effective. The UNGP makes it clear that disengagement is an appropriate action where leverage fails or is simply not feasible. Again, the open letter states in recommendation 2 that companies should be required to disengage in cases of gross and systemic human rights violations. Crucially, what this framework prioritizes is severity over the relationships. The more severe the abuse is, such as forced labor or systemic exploitation, the less tolerance there must be for prolonged engagement without results. At that point, maintaining the relationship is, again, as my colleague said, no longer neutral. It becomes active participation in sustaining the harm, which raises extreme moral concerns and legal concerns too. In any other context, businesses don't engage with serious illegality with other suppliers, and they exit immediately to avoid liability. Human rights abuses should be treated no differently. Yes, there must be remediation, but there also must be termination.
Thank you. Now for the final rebuttal for the team against the motion, University of Brighton, you have your 2 minutes.
Thank you. Our learned colleagues' argument sounds powerful. They say, stay in the contract and you're funding abuse, leave the contract and you've done your duty. But let's look at actually what happens when companies leave. Our learned colleagues assume termination ends the harm, and the evidence shows it actually moves the harm to somebody nobody is watching. The UNGPs are built on one foundational purpose, which is protecting people from corporate harm. Under the Vienna Convention of the Law of Treaties, even building instruments must be interpreted by their object and purpose. The object and purpose of every instrument in this field is the protection of rights holders, not the legal hygiene of corporations. After Rana Plaza, several brands exited Bangladesh entirely. They did not improve conditions, They moved their contract factories to Cambodia, to Myanmar, with no audit requirements, no leverage, and no Western brand presence at all. The workers who needed protection lost their homes, the abuse continued, the invisibility outside the frame of any due diligence process. And the BIICL, the British Institute of International and Cooperative Law, studied companies operating under the French and German mandatory due diligence laws. Their finding was clear. Companies that stayed and engaged produced better outcomes for workers than those who exited. The feared cut and run response didn't protect anyone. The opposition is not arguing for the workers in these supply chains, they're arguing for the brand's legal comfort. And consider who actually benefits from the mandatory termination. It's not the workers, because they lose their income overnight, and it's not the communities, because they lose the one buyer with any standards. The only party that actually benefits is the brand. They have clean hands, no liability, and no further obligations. International due diligence law is not designed to give corporations a legal exit strategy. It was designed to make them stay accountable. The law was designed to keep companies present, accountable, and financially exposed to the consequences of harm in their supply chain. And our position is that termination removes all three of these. Thank you very much.
Thank you. That marks the end of rebuttals. Now for the concluding statements. Auckland University of Technology, you have your final 2 minutes.
Thank you. Honourable judges and my learned friends. Now, the opposing team have told you stay and improve, but their argument fails for a simple reason. Improvement without consequence is not reform, it is delay. And critically, they present only half the law. Under the United Nations guiding principles, yes, companies must use leverage, but where harm cannot be prevented, they must act to seize or prevent that harm, including where necessary, ending the relationship. Under the OECD due diligence guidance, engagement is the starting point, not the end point. Where harm persists, companies must pursue responsible disengagement. And under the European Union Due Diligence Directive, termination is not exceptional, it is expected where necessary. And domestic courts are moving in the same direction. In Vedanta and in Okpabi, the United Kingdom Supreme Court confirms that corporations can be held responsible for harm across global operations. So the direction of the law is clear. Responsibility follows influence. The opposition says termination harms workers, but the greatest harm to workers is remaining in exploitation. They say engagement is better, but engagement without consequence changes nothing. They say leverage requires staying, but leverage without consequence is not leverage, it is tolerance. They say leaving removes influence, but influence that produces no change is not influence at all. Because at some point, continuing the contract is no longer oversight. It is endorsement. You cannot profit from abuse and call it compliance. Because when harm cannot be stopped, it must not be supported. And for those reasons, we ask you to affirm the motion. Thank you.
Thank you. And now for the concluding statements from the University of Brighton, your final 2 minutes.
Honorable judges, our team has constantly shown that termination causes harm are good, while engagement creates the conditions for real change. The key clash in this debate has been exit versus engagement. And the proposition gives you more clarity. It even compares companies' obligations to workers with the government's commitments under the Genocide Convention. However, they have touched on this for 5 seconds. I wish we could have talked more about it, but you have to ask yourselves, is it going to be convincing if you only scratch the threshold and do not thoroughly engage in the argument to actually convince people that a company and its workers is equal to a state and its people? Second of all, they say that we must stop complicity by cutting ties. We can turn this around. They say you should stop complicity because it's morally good. But on the other hand, we can also argue that companies have a moral obligation to remedy the harm they did. Every contract has offer acceptance and consideration, but it also has remedies. You cannot break the contract in two and say you will walk away. You must respect the rules and act upon them. On the other hand, we as the opposition give you real-world consequences, empirical evidence that international law actually encourages engagement. Furthermore, we also argue that we must protect human rights through protecting workers through engagement. Furthermore, even if the affirmative is morally appealing, they fall on outcomes. Their model removes jobs, removes oversight, pushes abuse out of sight, and not out of existence. Reality is that workers will work either way, even if you close the factory. We respectfully invite the judges to reject this motion.
Thank you. That marks the end of the debate. You are no longer assessed from this point, so feel free to relax, grab some water, just relax. But would also like to thank the judges who will be marking this match and the coaches supporting the teams. So the University of Brighton is supported by Aurélien Bucklow-Evans and Isile McQuad. Okay, with that out of the way, let's quickly reflect on the match that we just had before going over some fun networking questions. So starting off with the reflections, how did you find the topic at hand? What was the preparation stage like? And of course, the match itself, what was it like for you? So starting with the University of Brighton, could we hear from Mr. Peter Badika, please?
Thank you. I myself found this motion the simplest out of the three we have debated overall. The first two had something to do with environmental rights, and I have to say it's a breath of fresh air to debate about, for example, workers' rights or the economy. It's an entire different topic, and I find myself more in control of it. Like I can master this area more. I'm more in control. Thank you.
Thank you for sharing. Could we hear from Mr. Tremaine Thompson from AUT, please?
Thank you. Yeah, very, very similar. Our other match was around the environment as well, which we found more difficult than this one. There's a lot less gray area. There's a lot more law that can be, I guess, kind of really experimented with within our arguments. So this has been a great debate, and I wish we had more time to discuss it even further. But well done to our opponents. That was a really great match.
Thank you so much. Mr. Cameron Hall, how did you find this topic?
Yeah, mirroring what the two previous people have said, I think this topic was much more accessible to us. We can actually argue it either way. And I think, especially when we got our feedback from the other matches, we were able to really put it together and try to improve everything to a better degree. But I feel like we did actually apply it very well this time. So let the best team win.
Thank you. From AUT, Mr. Jazz Chugwal, how did you find the match?
I found the overall topic actually quite exciting. I heard one of my learned colleagues say a breath of fresh air. I think that's quite a good way to sort of state it. I love talking about morals versus rights, that sort of thing. So I found it really interesting. Yeah, in general, the prep was good. I think both teams did exceptionally well, and all the best.
Thank you. And finally, Mr. Mears, please.
Thank you. Yeah, I very much agree with Mr. Thompson that it was nice to have real kind of lines drawn. Although there's, I think there's law on both sides of us. At least the law is quite definitive on the side that we're arguing. Like I can point to one source that says exactly what I'm arguing, and my learned colleagues can do the same on their side. The past debates was a lot more iffy with specifically hard law. And I do agree that the motion is much more accessible, especially compared to our first one where we were completely under the water. We had no idea what it's about. Spend the first week figuring out the motion. This one is a lot more, okay, let's get into the arguments now and figure out what we're saying.
Cool. Thank you so much for sharing. And now for the networking questions. So starting off with the shout out. So you've had, at least the University of Brighton has had 3 matches already in AUT with their second match. And over the matches, do you want to give a shout out to any person or maybe societies that have been encouraging or inspiring you so far in this competition? So starting off with AUT this time, any of the members, please feel free to chime in.
Yeah, definitely. I think there's a lot of people that we'd probably want to shout out. Definitely our South Auckland Law Students Association, SALSA, who have been massive supporters, and I know that there are a number of them who are watching live on YouTube right now. Also our families. It's actually my birthday today, and my family has sacrificed dinner with me in order for me to be able to participate in this. So yeah, just wanted to say thank you to them for allowing that, so we could take up this opportunity.
Well, happy birthday on behalf of us. And yes, hopefully this was a very fun and insightful birthday for you. The same question now to the University of Brighton team. Anyone is ready, is free to answer.
Okay, I'm going to chip in a bit. So I like to say, first, I like to wish Mr. Thompson a happy birthday. We love you. Second of all, I'd like to shout out to our coordinators, Aurelian Beauclair Evans and Miss Ishnay. I think they have been with us throughout this this campaign, and they have helped us with every motion. We asked them for some advice, and they gave it to us. So I can say that our coordinators were there, and they were offering support. That matters a lot. And yeah, I would like to shout out to all the people who are watching from home. I love them as well. Hello.
Thank you. Thank you so much. All right. So now for the final question. And it's, is there a legal system, country, or institution and an area of law that you would particularly like to study or experience, and why? So I'll quickly repeat the question because it's quite lengthy. So is there a legal system, country, or institution and area of law that you would like to experience, and why? So starting off with the University of Brighton this time.
I'm gonna.
Sorry. I think we like to do the consent to harm, because I think we studied it at the start with the case of R.V. Brown, when it was the case of the sadomasochist. I know it's a bit of a dark subject, but it was very interesting to see how the law almost tries to police like sexual practices, and they try to put their normativity on top of it. So I think that would be a really interesting part of the law to study and dive into more.
Thank you. Would any of the other members like to chime in?
I'm interested in international law, and I haven't done it here in the UK, but I did study it in Germany for a semester, and I enjoyed learning about hybrid tribunals and how you have to like mix international law with local law when you have such incidents. For example, the Timor-Leste case. So I have to say that if I were to follow an area of law, I would look towards the international one, because I find it pretty interesting.
Thank you. And finally, Mr. Mears, is there anything you'd like to add?
Yeah, I'll just say for myself, I'm completely different area, but looking at the intersection of freedom of speech and humor, specifically satire, is something that really interests me. Where the line is drawn, whether you have a right to offend, et cetera, et cetera. So yeah, very different from the other two, but I'm excited about it.
Thank you so much. And now same question to the AUT team, please.
I think an area that's quite interesting and sort of curious is international humanitarian law. Tremaine and I participated in a Moot for the Red Cross, and since then I've been quite hooked actually, and they got me really onto it. It's really interesting, the fundamentals, the principles, that sort of thing. So that we're also doing, torts and that sort of thing. Our lecturer often refers to the French jurisdiction of negligence, liability, and that sort of thing, and that's quite interesting as well.
Mr. Tremaine, would you like to wrap up for the night?
Yeah, I think just kind of going along Thomas's lines, something a little bit unique. I'm really interested in pursuing education in canon law, Catholic Church law, and legal pluralism. So how different judicial systems can intersect and interact with one another in the same same area. So yeah.
Awesome. Thank you all so much for this match, and congrats for getting through and doing such a good job, and wishing you all the very best. Feel free to network with each other on LinkedIn. And yeah, passing it back over to Professor Laurent to wrap up the session. Thank you.
Yes, and I want to tell that it was a very, very nice match. I have to tell you have done a very research, a lot of, let's say, efforts on this. And one thing I want to tell you as well is that after this match, I will send you a link with the recording of the match from WebEx, which will be put as well on YouTube. The reason, because I saw there was a 10 seconds cut during the match. So this will be sent to you, and of course also to the judge, right after the match, to make sure that they have as well that link as well with the recording itself. From WebEx, from the platform. So voilà, it's what I wanted to tell, and as well there will be of course a networking session, but Auckland University of Technology still has another match, the day one match, which will be at the end of the month. So in this group, yes, it will be at the end of the month that we'll know the final result for the 4 teams in this group G. So thank you again. So we'll let, of course, the British team enjoying the rest of the day, and of course, yeah, to enjoy the night in Auckland, in New Zealand. So that was a pleasure, and we keep in touch and watch, of course, the other match for the next time. And happy birthday, Mr. Thompson. Voilà. Thank you, and enjoy the rest of the weekend with the birthday celebration as well. Thank you again,
Thank
and
you.
we keep in touch. Thank you. Bye-bye.
Hold on, goodbye.
Bye-bye.
Bye.
Thank you very much.